Good morning, this is your Kelso Report for Wednesday, March 28th, and I'm your host, Clark Kelso. Well, today we have a lot of criminal law. Criminal law in the Ninth Circuit, criminal sentencing, criminal procedure involving grand juries, criminal sentencing at the state courts, and then a case involving revenue and taxation. So let's get started with our Ninth Circuit case, our first one dealing with an area of criminal law. In this case, what do you do when you've got the wrong jury instruction? The defendant, in his capacity as the State Director of the United Public Workers, negotiated contracts with dental and health insurance providers, ostensibly on behalf of UPW members and their families. Well, the contracts included substantial consulting fees paid to some of the defendant's family members and to shell companies controlled by the defendant. And the fees were paid, guess what, even though no consulting work was done. A jury convicted the defendant of 50 counts of theft of honest services from the UPW and its members. The jury also convicted the defendant of conspiracy, embezzlement, money laundering, and healthcare fraud. After the Ninth Circuit affirmed his conviction on appeal 5 years ago, the Supreme Court in 2010 decided in Skilling v. United States that the crime of theft of the intangible right of honest services, as described in 18 U.S.C. section 1346, is limited to conduct that encompasses bribes and kickbacks, because any broader construction would be unconstitutionally vague. Well, the jury had not been instructed with this limiting interpretation, and the defendant challenged his conviction in habeas. In United States v. Rodriguez, the Ninth Circuit, following a searching examination of the record, concluded beyond a reasonable doubt that the instructional error had no substantial and injurious effect or influence in determining the jury's verdict. In short, the evidence was so overwhelming that the financial arrangement constituted a kickback. It easily satisfied the requirements imposed by Skilling for finding harmless error. Next, another sentencing issue, this time in federal court. The defendants conducted a series of armed robberies over a 6-month period. They were caught and indicted for conspiracy to interfere with commerce by robbery in violation of 18 U.S.C. 1951, and then in a series of firearms violations, including conspiracy to use, carry, brandish, and discharge firearms during and in relation to a crime of violence in violation of section 924, 6 counts of discharging a firearm during and in relation to a crime of violence in violation of 624C, 24 counts of brandishing a firearm during and in relation to a crime of violence in violation of 924C, and 30 counts of interference with commerce by robbery in violation of section 1951. They were found guilty, and because of the mandatory minimum concurrent sentences provided for in section 924, they were sentenced to around 745 years in prison. Well, the court affirmed those convictions and rejected an argument that these sentences violated the Eighth Amendment, citing a series of Ninth Circuit cases upholding 100-year sentences. The court did agree with the defendants that the trial court had improperly ordered the conviction, such that the sentences were 3 years longer than they should have been. The order of convictions does make a difference, interestingly enough, in how sentences are calculated under section 924. Where all the convictions occur in one trial, there's no easy way of determining the order. So the Ninth Circuit held that the rule of lenity required the trial court to order the convictions to minimize the length of the sentences. So they got a 3-year reduction. Not exactly much of a victory when you've got a 745-year sentence. Next, we turn to a state court decision involving grand juries. The defendant had been convicted of murder and several other crimes. On appeal, he alleged that the grand jury indictment should have been quashed because the grand jury's formation and composition violated his Sixth Amendment right to a jury, drawn from a representative cross-section. In order to establish a prima facie violation of that fair cross-section requirement, The defendant must show that the group alleged to be excluded is a distinctive group, that the representation of this group in veneers from which juries are selected is not fair and reasonable, and that the underrepresentation is due to a systematic exclusion of the group in the jury selection process. Well, in People v. Romero, the 3rd District noted that the defendant had failed to identify any aspect of the jury selection process that would result in systematic exclusion of Hispanics and Asian Americans. To the contrary, the jury commissioner testified, and the evidence supported her testimony, that she makes a lot of effort to reach out to organizations representing minority groups, and that she reaches out to those with ethnic-sounding names. So, absent any allegation or proof by the defendant that the grand jury selection process systematically excluded any group, the 3rd District rejected the defendant's 6th Amendment claim. Next, a criminal sentencing case involving sex offenders. In 1999, the defendant pled no contest to a charge of committing lewd acts on a minor in violation of Section 288 of the Penal Code. The defendant was 19 at the time, and the victim was his 13-year-old girlfriend. Now, more than 12 years later, he sought to be relieved of the lifetime requirement that he register as a sex offender, arguing that the requirement violated his right to equal protection. The trial court found on uncontradicted evidence that the defendant poses no threat of engaging in future sexual misconduct, and while the trial court stated it would have preferred to grant him relief, it was compelled to deny his request on the basis of prior appellate authority that could not be fairly distinguished, holding that equal protection was not violated. Nevertheless, the court did suggest that the defendant might consider seeking a certificate of rehabilitation, since such a certificate might relieve him of the registration requirement. Under current law, a sex offender convicted under Section 288 is not eligible for a certificate of rehabilitation, but other sex offenders are. So the appellate court's suggestion is to litigate the equal protection challenge in the context of a request for a certificate of rehabilitation. Since the defendant had not yet done this, the court affirmed the dismissal without prejudice to the defendant's right to apply for a certificate, and if granted, to be relieved of the registration requirement pursuant to Section 290.5. This is what we call in the trade a judicial assist. Finally, a revenue and taxation case under Prop 13. The California Constitution exempts certain transfers that otherwise would be a change in ownership for tax assessment purposes. In Duea v. County of San Diego, the focus was on an exclusion from change in ownership for real property that was acquired as a replacement for comparable property following the exercise of eminent domain proceedings or real property acquired by a public entity. Now, the plaintiff factually in the case sold his property under threat of condemnation to a downtown development company. The San Diego Tax Assessment Board rejected his claim that this sale fell within the exclusion, and he appealed. The 4th District rejected the taxpayer's argument. Selling in threat of condemnation is simply not the same as selling following the exercise of eminent domain proceedings. And although the private developer was working with the city on downtown revitalization projects, there was no evidence the private developer was acting as the city's agent, which might have triggered the public entity exclusion. Absent evidence of those two exclusions, the purchase of the new property was treated as involving a change in ownership. And that, of course, results in a reassessment. That's it for today's Kelso Report. Have a great day in the law.